It's about the People's Democratic Party. The Supreme Court has made a ruling, and it is time for us to get a sense of how the different parties within the same party are taking this. We're joined on the program by member PDP Ministers Forum, Mr. Humphrey. Abah, former minister as well, joins us live from our Abuja studio. Good morning, Mr. Abah, and welcome to the program.
Good morning. How are you?
Well, we're watching and seeing if the PDP would move on from this point or still try to resolve all of the issues. On the one hand, the Supreme Court made a pronouncement saying, well, that Ibadan Convention should not have happened. It was contempt of court. It shouldn't have gone to a court of, equal jurisdiction to try to get a ruling when that case was already in court. You shouldn't have done that. But we've seen, Minister Wike releasing a statement saying, well, no more factions. We've also seen the Seyi Makinde wing in the APC and the PDP, forgive me, having their meeting. We've seen the chairman of BOT, Adolphus Wabara, saying we're now taking over. So with that court's pronouncement, it looks like there's still very much present faction within the PDP.
Well, thank you very much. I don't think we have agreed as to the issues of factions. The Supreme Court ruling yesterday was very clear. Like you said, it annulled the Ibadan Convention, and there was also another arm of the judgment that people are not referring to, and that is the arm that also upheld the Court of Appeal decision that recognized the suspension of the 4 officers that dovetailed into the end of their tenure. So whatever those 4 officers had done thereafter remains a nullity. They cross-appealed on it. They cross-appealed on it, and the Supreme Court, they lost on the cross-appeal in the Supreme Court. And that is substantial. It's substantial, very substantial. So as it is, the PDP has a constitution, and the elders of the party, principally beginning with the Board of Trustees, have decided to step in and to do the needful as outlined in our constitution. So the context and the crisis that has been in PDP has actually been about the National Working Committee. People do not realize that we have other executive organs. For instance, we have the National Caucus, we do have the National Executive, we do have the Board of Trustees, and then you now talk about the National Working Committee that is an integral part of the National Executive Council. So I know, as a matter of fact, that following from yesterday's decision of the Supreme Court, NEC members are in the process of setting up a meeting, and that will be done as soon as possible.
So who is in charge of the PDP as of today?
Of course, there is a Board of Trustee chairman who can call all parties to order. And he issued a press statement at the close of the decision of the Supreme Court yesterday evening. So the Board of Trustee chairman is Senator Adolphus Wabara, and effectively he's on behalf of the Board of Trustees.
Right.
He's playing the role of this man. But
pardon me, the FCT minister reaffirmed that the convention of the Abdurrahman-led group remains valid. So he's not relying on the appeal that affirmed the suspension of Mr. Yahu and the rest. He's saying that, well, the Abdurrahman-led group remains the leader, or at least leadership for the PDP.
Well, people are entitled to their views. But as far as the decisions of the Court of Appeal and the Supreme Court on these matters are concerned, That would be a preposterous position to take, with due respect. So I think people, all of us who are members of the party, should be properly guided by the decisions of court. You cannot put something on nothing. You cannot build on emptiness. The 4 members of the former National Working Committee who were on suspension as at the time they allegedly tried to put together a caretaker committee and consequently went ahead to organize a supposed convention. Clearly in breach. They are clearly in breach. Except they are claiming they don't want to obey the rules of the decisions of court. They are the ones that went to court, and they must, having submitted to the courts, we are all bound to obey the final decisions of the same court.
So let's talk about timing. Timing is critical. I'm going to stay with the issue of this division because these days sometimes, even for the courts, the final court in the land, which is the apex or the Supreme Court, we still have multiple interpretation of things that come from the court. So there is one that is not ambiguous, which is the fact that the Turaki-led in the PDP is not existing in the law because it's been nullified by the Supreme Court. So there is no debate about that. The debate is on this part of the suspension. So since you're a lawyer, walk us through timing and help me out if I'm wrong with my timing. I understand that early November, perhaps 1st of November, Anyanwu and the rest members that were suspended for 30 days. So is it within those 30 days that they were suspended that they formed themselves in part of the NEC to inaugurate Abdurrahman as the leadership? So if that is true, by whatever verification has to be done to verify that, does that invalidate consequential action because they were part of the process? So what I mean by that is, if they now set up that caretaker committee or whatever they did, were there correspondences from Sam Anyanwu whilst he was the suspended national secretary of the party within those 30 days? Those correspondences, are they available? That's on one hand. On two, they are even saying that, let's even accept without conceding that, yes, that happened in court. Now it's academic because 30 days elapsed. So I want you to speak to the question of timing and consequential action based on the suspension.
Oh, okay, thank you. Now, the issue of the suspension was raised in the appellate court by leave of court. The matter was raised in the appellate court by the lead counsel to the Turaki-led group. And the appellate court rightly came up with a final decision stating that the then legal advisor who was putting himself forward to represent the party and to exercise the functions of the national legal advisor on behalf of the party was functus officio because he had been suspended from the party and that suspension dovetailed to the end of tenure. Note that this suspension dovetailed to the end of tenure for the last National Working Committee. I also need to bring to your attention the fact that this gentleman, especially the National Secretary, was also asked to appear before the disciplinary committee for a final position to be taken on his issue. And that led him to go to the Federal FCT High Court. He went to the FCT High Court to try to challenge that exercise of power by the disciplinary committee of the party. And FCT High Court in January this year gave a judgment on the issue, also affirming that his suspension was legitimate and that he no longer remained an officer of the party by the time the disciplinary committee took their final decisions. The FCT High Court confirmed the actions of the decisions of the disciplinary committee of the party. So the 4 of them who were actually suspended were within the time frame of their tenure lapsing. And whatever they did during that period has no effect, because at that point in time, they were no longer officers of the party. And I need to also bring to your attention that the National Working Committee is made up of about 13 to 17 people. And it will be absurd for you to say that 4 people will take a decision on behalf of the rest of them. Albeit these 4 are people that have been suspended from their offices. So the Court of Appeal rightly assumed jurisdiction to listen to the matter, and they made a serious in their judgment, they made serious observations on the conduct of counsel.
Just a moment, as we to wind. If I may butt in, so the argument about being an academic exercise in law, where does that stand?
No, it's not an academic exercise because it's a factual thing. Because it is following from that fact that they are assuming the rights of action to function in an office. So if you say it's academic, then you are right. You are also trying to write off all the things they have done. And that's our position, is that these are factual matters. These are people who no longer have the right to represent the party. So whatever they did thereafter was null and void. So it's not academic. It's a fact. So anybody who thinks that they still exist to act or function, and as such, whatever they did consequent to their suspension was valid, must be acting in error. So I think that the proper course of action for people to take is to respect the decisions of the 2 courts, the Court of Appeal and the Supreme Court, and get back to listening to the other organs of the party, i.e. the Board of Trustees, the NEC, National Executive Committee of the party, and then the National Caucus. These 3 organs of the party are there, and I think they are currently meeting to try to reposition the party and get it to move forward. Because of those who want to contest election. Because of those who are prepared to represent elections. Yes, please.
The Wike Group, through its National Publicity Secretary yesterday, did insist that the suspension was an academic exercise, and that in fact the National Publicity Secretary of the Makinde Group was flustered and had to be called to order by the Lord Justices yesterday in court, and that he came out misinterpreting what the Supreme Court ruled on the suspension of the Iron One others. But perhaps you want to respond to that. But still on the matter of timing, now that you say that Senator Adolphus Wabara, leading the BOT, has taken over the affairs of the party, what is the strategy of the Makinde Group, especially within the context of timing, on how to resolve the party issues ahead of May the 31st, which would be the deadline for the presidential primaries?
Number one, anybody who is contending that what the Supreme Court did was an academic exercise is speaking out of, with due respect, I would say, out of ignorance. The Supreme Court cannot be engaged in matters that are as serious as this, that go to the root of democratic establishments of our nation, and you say they are doing academic exercise. These are respected jurists who have spent their time to go through files and read through judgments and come out with decisions that will guide us. And then somebody sits in his corner and calls it an academic exercise. That's an insult. Secondly, you talk about the publicity secretary being flustered in the Supreme Court. No, maybe he does not understand the conduct of counsel in court. If he was a lawyer and he said that, then I would have been very annoyed. But I will excuse him because maybe he doesn't know the practice and procedure in court. What the Lord Justices were correcting the publicity secretary for was that because of the congestion in court, where he was seated when the case was called and counsel and started announcing appearances, there was no microphone by his place. I was in court. So he had to move to the table where there was a microphone, and other lawyers were seated there. So he decided to put on the microphone from outside the bar. So the Lord Justices corrected him that, look, you cannot speak from outside the bar. You need to properly sit in the bar. So he had to move in and sit at the bar to announce his appearance and all the other lawyers that went with him. So I do not see how that became an issue for somebody who claims to be a publicity secretary. He needs to have some understanding of how the court functions. Now, on the issue of timing, yes, time is of the essence in this matter, particularly because of the timetable of the INEC and the Electoral Act 2026. The elders of the party are conscious of the issue of time, and they are working assiduously to ensure that we get across to INEC and get across to all party members so that we can be within time. That is why we are not dragging our foot. As I talk with you, people are meeting today, people are meeting tomorrow on the same issue, so as to expedite action in the implementation as a fallout of the decision of the Supreme Court. So anybody who decides to ignore the decisions of the Supreme Court on this matter does so at his own peril.
Well, Mr. Humphrey, we have to thank you for your time. It's been, well, interesting listening to your own side of this, and definitely this is an ongoing conversation. So Humphrey Abah is a member of PDP Ministers Forum, also a former minister. You know, maybe someday, very soon, we'll have a conversation with you on security, the police, interior, and the rest, which is a core area that you oversaw when you were minister. But we have to thank you in the meantime. So Humphrey Abah, wish you the best.
Thank you very much. Thank you very much. And happy May Day to our workers who are going through very challenging times.